Next, I'm going to discuss a rule change, um, regulatory change. I know that rule changes don't seem like a very exciting topic. However, this particular rule has to do with independent contractors. It provides guidance, guidelines for determining whether a worker is an employee or an independent contractor. And that is a big deal because independent contractors um, are not protected by the minimum wage and overtime laws. They are not covered by workers' comp, unemployment comp, by the civil rights laws that govern employment discrimination. And so if somebody is an employee, they will have more legal protections, let's put it that way, than if they're merely an independent contractor. And so what this rule change does is it reinstates what lawyers call the economic reality test, or a test to try to determine whether a worker is economically dependent on their employer to the extent that they have to be or should be characterized as an employee instead of an independent contractor. And to make that determination, the Department of Labor, as well as the courts, will apply this economic reality test, and that test includes 6 factors. Those factors include: number one, the opportunity of the worker for profit or loss, depending on managerial skill. So if somebody is like a business, they can get a profit or they can lose money on the project, and there's some management skill involved, then that factor would weigh in favor of holding that the individual is an independent contractor. However, if they aren't operating in that way like a business, then that factor would weigh in favor of determining that they are an employee, not an independent contractor. The other factors are number two, investments by the worker and the employer. For example, if the worker supplies or pays for their own tools and their own supplies, or is making other out-of-pocket investments in the project, then it's likely they'll be determined to be an independent contractor. If not, they're more likely to be classified as an employee. The third factor is the degree of permanence of the work relationship. If it's just a temporary work relationship, then there's that will weigh in favor of saying that they are an independent contractor. If it's a more long-term or more permanent relationship, then they're more likely to be characterized as an employee. That does not mean that all temporary workers are independent contractors. This is just one factor, and often is outweighed by the other factors, but it is one of the 6 factors that will be considered. The fourth factor is the extent to which the work performed is an integral part of the employer's business. For example, if somebody is a plumber and they're working for a plumbing company, that strongly suggests that they're an employee of the plumbing company, not a contractor. If they're a plumber and they're doing a project at somebody's house, then that may weigh in favor of saying that they're a contractor and not an employee of that homeowner. The fifth factor is well, actually, I skipped over one factor. One factor is the nature and degree of employer's control over the work. This factor is pretty obvious. If the employer is supervising all of the work, is basically telling the worker what to do, or for the most part is telling the worker what to do, then that suggests that the worker is an employee. On the other hand, if the employer has a project and they hire somebody and that person basically decides how to do the work, has control of the work. They are not receiving much supervision by the employer, then that would weigh in favor of their being classified as an independent contractor. And then the last factor, the sixth factor, is the worker's skill and initiative. Now, let me give a warning about this. Just because a worker is highly skilled, that does not necessarily mean that they're a contractor. First, because this is just one factor, but secondly, it's not just the level of skill of the employee, but also whether they can use that skill to take initiative on the job. And this may be somewhat similar to the degree of supervisory control, a factor which you've already discussed. I mean, if a worker is highly skilled and they can pretty much decide how they're going to do the work and take initiative in figuring out how to do it, then they're more likely to be classified as an independent contractor. On the other hand, if they don't have that kind of initiative, if they can't use their skills, let's say they have skills as a worker in the building trades, but they don't have the initiative to sort of determine what they're going to be doing, then it's more likely that this factor would weigh in favor of their being an employee. So again, there are these 6 factors under the economic reality test. I know that for some of you, this may seem like a lot of legal jargon, but it is important. And it's also important to realize that none of these factors by themselves are determinative. The Department of Labor or a judge has to consider evidence regarding all 6 of these factors. None of the factors are necessarily more important than the others, but based on consideration of those factors, the court or the Department of Labor or the state wage and hour enforcement unit at the Department of Commerce will then determine whether the worker has been misclassified. Misclassification normally occurs when a worker is misclassified as an independent contractor rather than employee, and employers have an incentive to hire people as independent contractors because, as I pointed out earlier, their workers would then not be protected by many of the employment laws because they aren't employees. So that's my discussion of the independent contractor rule. The last thing to know about it is that it actually becomes law, although it's published in January. It actually becomes law. That is, it takes effect on March 1st. So less than a month from now, this new rule will be the law in Ohio and across the country.